Thank you for starting the recording. Hi, everyone. I am Akila. I'm one of the board members from WeEMBRACE, and we have our first series of webinars, seminars, whatever you call it, is starting now. We have Leilani, Maria and Mary from SSI. Oh, there you go. So today we're going from DRC, and today we're going to be talking about SSI and SSDI, and you'll be getting a lot of information. It's my husband talking to me. So, sorry about that. So we're going to be getting lots and lots of information about this, and we're going to have a follow-up workshop next week also. So please go to our website and sign up for subscribe for our newsletters. That would be great. And you can also find out about all the other programs we're offering. So I'm going to pass on to Mary first.
Thank you, Akila. Good afternoon, everyone. My name is Mary Rios. I'm one of the senior advocates at Disability Rights California. And we also have Lonnie Pfeiffer and Maria Iriarte. So we are from Disability Rights California, formerly known as Protection and Advocacy. We are a public interest law firm, and we cover the entire state of California. We have offices throughout the state in Sacramento, Oakland, Fresno, Los Angeles, San Diego, Ontario, and many other regional offices. We cover a large area from special education, regional center issues, public benefits issues, such as SSI, in-home supportive services, Medi-Cal, mental health issues, housing issues, and many more services. If you have any questions, please feel free to put them in the chat. You can raise your hand. All the materials, as Maria said, are going to be provided to you. And if you would like an appointment to speak to the attorney, I am going to put my information in the chat. You can feel free to reach out and contact me. I will do a conflicts check to see if there is, if you're working with a sister organization of ours, which is Office of Clients' Rights Advocates. Other than that, our services are free. So with that, I'll go ahead and turn it over to Maria.
Hey, good afternoon, everyone. So
sorry, I was supposed to turn it over to Lonnie. Sorry, Maria.
Oh, okay.
Hello, everyone. I'd like to present our presenter this afternoon, Maria Fernanda Iriarte. She's our senior attorney who is a member of the Legals Clinic Project for Disability Rights California. Her expertise is in the area of public benefit. She has a bachelor's of science in business administration from California State University, Long Beach, and a Juris Doctorate degree from Loyola Law School. So with that, I'll go ahead and turn it over to Maria.
Thank you, Lonnie. So as I mentioned before, there's a lot to cover. And in the first probably 30 to 40 minutes of our presentation, we're going to focus on one criterion to get SSI. And it's that you have to show that you're disabled, unless you're 65 or older, because if you're 65 or older, you don't have to show that you're disabled. But if you're below the age of 65 and you want to apply for SSI, you're going to need to show that you're disabled. So, and there's a process, and there's a definition for disability for children and a different one for adults. And we're going to go through all of that process. It's really important part of the application process. We're going to talk about other criteria for SSI, which includes limited income, limited resources. We're going to talk about, when we talk about resources and income, we're going to talk about the deeming concept, why some kids who are disabled can't get any SSI until they reach the age of 18 and they apply. We're going to talk about qualified alien status, which is another criterion for SSI. Rights and responsibilities. Once you're on SSI, what are your rights and what are your responsibilities? And then applying for SSI. By the way, starting tomorrow, all of the Social Security offices are open for business. So that's a good thing. It's been difficult trying to do things, otherwise when you can't go into the office. We're going to talk about the, so SSI is a needs-based program. You have to have limited or no resources, limited or no income, and meet all this other criteria. On the other hand, Social Security administers the Social Security Disability Insurance Program, and that program is based on FICA taxes that you paid through work. You paid those FICA taxes to build up your Social Security, so when you retire, you get a retirement from them. It goes towards your Medicare, and it also goes towards this program, Social Security Disability Insurance. Should you become disabled before your retirement age, you may qualify for this benefit. And by the way, the Social Security Administration administers other benefits, disabled widow benefits, widower benefits, divorced spouse benefits, children's benefits, disabled adult child benefits, so retirement benefits. So it's a really big agency with a lot of work to do. And then we're going to talk about appeals, what the appeal process is like, representation in case you're interested in getting an attorney, how does that all work? And if we have time, because it depends on how many questions we get throughout the presentation, helpful suggestions, but these are things that you can read on your own, stuff that I have some of the stuff that I will mention throughout the presentation. So let's go ahead and get started. So when you apply for for SSI or SSDI, you have to show that you're disabled for SSI, unless you're 65 or older. Now, let's say that I get my application and I submit my application and records to the Social Security Administration. What's going to happen is that the Social Security Administration is going to determine whether you have, you meet the countable income rules, the countable resources rules, the qualified alien status rules, of course, California residency. They're going to determine this. They're not going to determine whether you're disabled. That's another state. It's a state agency called Disability Determination Services. And so your packet, your application, and other paperwork is sent to Disability Determination Services. There, it'll be assigned to an analyst, and it's the analyst who will determine whether you're disabled or not. Excuse me, I've been having a cough forever. So Disability Determination Services is a state agency. And by the way, they also do the disability determination for Medi-Cal. So if you're applying for Medi-Cal and it's based on disability, they do the same determination. They use the same rules first that the SSI and the SSDI program use for determining disability. Now, it's possible that the analysts may find that there's not enough information in the file, and may ask your doctors and other providers, schools, whatever, regional centers for information. And it might even ask you to attend a consultative exam. That's an examination with one of their doctors. Maybe they want additional information. Maybe they want to verify whatever it is in the information that they've gotten already. And you have to do it because you have to cooperate with Social Security, right? You have to cooperate with the process. So knowing that, I'll call Social Security. Let's say I've applied. I'll call Social Security and ask if the packet is with DDS, Disability Determination Services, not to be confused with DDS for Regional Center. So they'll say yes or no. And if yes, I'll ask, well, what office is it at? And then let's say they tell me that it's the Central Valley branch. Well, I've got the information here. Here is a list of all of the DDS offices. I'm going to call that office and I'm going to ask to speak to the analyst, because I want to work with the analyst. I want to make sure that the analyst gets everything that he or she needs to make a favorable decision, right? So if I talk to the analyst and she says, well, we haven't heard from Dr. X, I'll say, you know what, I'm going to get a hold of Dr. X and make sure that you get that information. It's really important, because I don't know what the percentage is, but not all doctors respond to these requests, right? And if you don't follow up, if you don't, oops, if you don't, can you mute please, because there's an echo. Okay, so if you don't know what's happening, you're not going to be able to help the analyst, right? Because you don't know that the doctor hasn't responded to the analyst. So you want to become their friend. You want to make their work easy, right? You want to make sure that that the analyst has everything that he or she needs in order, because at some point the analyst has to make a determination. And if there's not enough information in the file to determine that you're disabled, they're going to deny. And then you have to start the process of appealing, and you really don't want to go there. So I'm going to next talk about the definitions of disability, and then two concepts, presumptive eligibility and compassionate allowance. And all these links will take you directly to the documents I'm showing you. So the definition of disability for an adult, and so for purposes of Social Security, SSI, an adult is anyone 18 or older. And the definition of disability is right here. It says that the law defines disability as the inability to engage in any substantial gainful activity. What it really means is you can't work and earn for this year. This is substantial gainful activity. This year, if you're someone who is not blind and you're applying for SSI, the amount is $1,350. If you're applying as a person with a visual impairment, the amount is $2,260. So what this definition means is that if you are engaged, if you're working and earning at least $1,350, you are not disabled, right? So not only that, so you cannot be working and earning at least $1,350. And by the way, that figure changes every year. And you have to show that your disabilities or disability is expected to result in your death, or expected to last at least 12 continuous months. Now, the definition for a child is very different. It focuses on functional limitations. So the child's disability or disabilities have to cause marked and severe functional limitations, again, and that the disability or disabilities are expected to last at least 12 continuous months or result in the death of the child. These are it. So what happens when a child has been receiving SSI and turns 18? They're going to get a letter from Social Security saying, we're going to have to redetermine your eligibility for SSI, for example. Why? Because now they're going to apply the adult definition of disability. And you may get a letter saying, okay, you continue to be disabled, or you do not continue to be disabled. It's because they have found that the person, and we're going to go through the analysis that the analyst does at DDS, so you understand why sometimes, even though the child may have received SSI as a child, as an adult, it changes. Now, I'm not saying that Social Security is right every time with their decisions, but at least you'll have an understanding of what happened. So this is really important. And there's a different definition for people who are applying for SSI or SSDI based on blindness. So this is the definition. It's statutory blindness, and you can just read it here. I'm not going to read it, but it's there. And it's for children and adults, doesn't matter. So I'm going to stop right now to see if there are any questions about what I've said. Or questions. There is a concept called presumptive disability. And here is where they say, look, based on this disability, we will most likely find this person disabled. So let's start paying this person right away while the analyst does the disability determination, right? And of course, Social Security does the other stuff for the other criteria. If the analyst determines that the person is not disabled, then you don't have to pay the money back. But this is called presumptive disability, eligibility for SSI. And those conditions are listed here. So amputation of the leg at the hip, allegation of total blindness, deafness, allegation of bed confinement or immobility without a wheelchair, walker, crutches due to a long-standing condition, allegation of the stroke. And you see that there are other criteria to all of this. Allegation of cerebral palsy, muscular dystrophy, muscular atrophy with marked difficulty, walking, speaking, coordinating hands and arms, allegation of Down syndrome, and allegation of autism spectrum disorder, for example, with the complete inability to independently perform basic self-care activities such as toileting, eating, dressing, and bathing, and the person who's applying is at least 4 years old. And then these here have to do with weight of the child at certain points, allegation of HIV, someone who has a terminal illness, someone who's had a spinal cord injury, and more criteria there, someone with end-stage renal disease, or someone with Lou Gehrig's disease. So if your condition is on the list, it's possible that they may find you presumptively eligible. And that's one way to do it. The other way to do it is if your condition is in the list of compassionate allowances. And here's the link to this website. And so let's say that you have leukemia and you want to know if your condition is in the list of compassionate allowances, because if it is, you will be found disabled and the disability determination process will be very quick. I mean, we're talking weeks, maybe. So let's say that I have leukemia. I click acute leukemia and it'll tell me just what I need to prove in order for my condition to be considered under the list of compassionate allowances, how severe it has to be, what kinds of evidence they'll consider to determine whether I have the acute leukemia that's going to get me found disabled, right? So you can imagine there are many, many, many disabilities here. This is just a sample of the first page. So there's a lot here. So those are two ways that, one, presumptive eligibility, boy, you've got one of those conditions that we're pretty sure we're going to find disabled. And then the compassionate allowances is we know we're going to find you disabled, and your process is going to be quick. But remember, there's other criteria, limited resources, limited income, qualified alien status. There's all of that still has to be met. We're just talking about disability. So what happens when the analyst is ready to make a decision about my case, say, for example? So this is the sequential analysis. This is what's done in every case. And maybe along the way, the person is found disabled or not. But there are 5 steps that it's possible the person may have to go through. So the first question the analyst is going to ask is, Maria working at substantial gainful activity level? If I'm working and earning at least $1,350 because I'm not claiming based on blindness, then the analyst is going to say, Maria, you're working substantial gainful activity. You are not disabled. Goodbye, right? But let's say that the analyst says, no, Maria, you're not working substantial gainful activity. So the next question is your condition severe enough, Maria? So is your condition expected to last at least 12 consecutive months or result in your death? Well, let's say that I was involved in an auto accident. I broke my arms. My doctor says, Maria, you're going to be out of commission for at least 11 months, including physical therapy. So if that's the information that the analyst has, then she's going to deny the application because she's going to say, your condition is not severe enough. It's not going to last 12 consecutive months, at least 12 consecutive months. But let's say if the analyst finds that my condition is severe enough. The third question that the analyst will ask is, well, Maria, is your condition in the listing of impairments? When you get the material, you could actually just click on here and it'll take you to the listing of impairments. If my condition is in the listing of impairments in the severity that it requires, then the analyst is going to say, you know what, Maria's condition is in the listing of impairments. I'm going to find her disabled. But let me show you what that listing of impairments looks like. I'm sorry about this. It's called the listing of impairments is in the blue book. There's a book that Social Security authors, and it talks about the disability determination process. A lot of the material I'm presenting to you is from the blue book, but the blue book also has the listing of impairments. Most of the book is the listing of impairments for adults and for kids. And the listing of impairments look like this. So if you're an adult, let's say that my condition is a digestive condition. And so the analyst would go to digestive systems to see if my condition meets the requirements, right? And if my condition is in the listing of impairments and the severity that needs to be, then the analyst will find me disabled. Same for child, right? If the child's conditions are in the listing of impairments, the child will be found disabled. But what happens if my condition is not in the listing of impairments? Then I go to step number 4. The analyst is going to say, okay, so can Maria do the same work she did before? Well, I'm an attorney and I do a lot of work with my hands. I type and I also read. I use the computer a lot. And so if my employer provides me with a reasonable accommodation, and let's say I can't use my hands anymore, I just can't type, I can't do any of that. If my employer can give me a reasonable accommodation of, there's technology that I can use that would allow me to do my work without having to use a keyboard. So if I can do the same work I did before with reasonable accommodation, what? The analyst is going to say, Maria, you can do the same work you did before, even if you have to use reasonable accommodations, you are not disabled, right? So what if she finds that I can't do the same work I did before? So then the last question, here's where it gets a little hairy. Can Maria do any other type of work, given her disabilities, her age, her work history, her education? Can she do any other type of work? And in the last 2 steps, 4 and 5, the analyst is going to work closely with a vocational rehabilitation expert. That expert is going to be critical in determining whether or not I can do the same work I did before or whether I can do any other type of work. And it's possible that even with my disability, the vocational rehab expert is going to say, well, Maria can do these 10 jobs, despite the fact that she's got these disabilities. And so then they're going to send me a denial letter. Then my only option will be to appeal. And I have to show, especially if I go before a judge, I'm going to have to explain to the judge why I can't do those 10 jobs that this vocational rehab expert has said I can do. I mean, I can talk about it, but really I'm going to need to have some expert too, because it's a battle of the experts at that point, to say, well, no, that expert is wrong because of this or that or the other. So this is where you can see in this sequential analysis where people, even though they're disabled, can be found not disabled under the definition of, the Social Security definition of disability, right? There's information here. These are just, you can find more information on, there's a vocational expert handbook. There's also, and this is part of it. This is another good one. It explains to you their role, the role of the judge, the disability determination process, what they do with the hearing, how they put their, what it is they do, how they prepare. This is the sequential analysis that we've gone through. So it's really important that if you're denied because they say that you can work, if you appeal, you're going to need to know, you need to know the sequential analysis, which you now know. You need to know that you're going to have on the other side some vocational experts saying why you could work and earn substantial gainful activity. I'm just going to go through this one and then I'm going to stop and ask if there are any questions. So this is the blue book. If the child's disabilities are not in the childhood listings of impairment, then what DDS is going to do, the analyst is going to do, is it's going to look at 6 domains. The analyst is going to look for information and needs information on the following 6 things: the ability of the child to acquire and use information, attend and complete tasks, interact and relate with others, move about, manipulate objects. They're looking at fine motor skills, gross motor skills. What is the ability of the child to take care of him or herself? And a general category of health and well-being, where you take everything into consideration. This publication talks about all of this, and I'm not going to go through it. You're going to have it. But this is what's important. If you're applying for a child and the child is not presumptively eligible, the child's disability is not in the list of compassionate allowances, the child doesn't meet the blue book listing of impairments, then you're going to need, one way or the other, you don't know exactly what's going to happen in the sequential analysis, but when you make an application for a child, you should be providing this kind of information from IEPs, from IPPs, from doctors. That's why it's really important what is in the IEP and the IPP, not only for school, but for other programs. Like for the IHSS program here in California, they're asking for IEPs, they're asking for IPPs so that they can see what it says about, the services that you're asking for your child. And you need to make sure that the documents that you submit to Social Security are consistent in the facts. Because if the IEP says one thing, the special ed contract between the parent, the school district and the child, or if you're IPP, we have regional centers in California, and if you're a regional center client, it's for people with certain developmental disabilities at certain severities. They also have a contract similar to an IEP. It's called an IPP. And, the information has to be consistent. If the facts are different, you're in trouble. Because, imagine getting documents that say different things about the same thing, right? What's the analyst going to do with that? Probably not use it at all. And try to find other things. So this document is really important to have and to read, and to make sure that you include information on all of this, because you don't know if you'll have to get to this point, right? So I'm going to go ahead and stop right now, because the next thing these 2 forms you're not going to get with your application. There's the physical residual functional capacity assessment, and there's one for the mental residual functional capacity. My recommendation is that you work with a doctor to fill this out and provide it to Social Security with your application or when you're being redetermined for the benefit, whether it be SSI or SSDI, because what happens, remember in the sequential analysis, can Maria do the work she did before? Can Maria, or number 5, can Maria do any other work based on her disability, her education, her age, etc.? Well, sometimes the analyst doesn't have this kind of information. What are my residual functional capacities, right? And sometimes, and the analyst will ask the doctors for the information, and they'll send this form to the doctors to fill out. Well, I can tell you that, and I'll bet that the majority of your doctors wouldn't know how to fill this out, because it's not the kind of stuff that you talk to your doctor about. Like, say, for example, I have my regular doctor, general practitioner, and I give my doctor this form and I say, can you please fill it out? And the doctor's going to sit there, and the first question is exertional limitations. Can Maria occasionally lift or carry less than 10 pounds, 10 pounds, 20 pounds? The doctor's not going to, I've never talked to my doctor about any of this. She's not going to know how to answer the question, and she may not answer the question because she doesn't know or guess based on what she thinks she knows of me. So my best advice is that you work with the doctor, make the appointment to get it filled out properly. So for example, let's say that my situation is I can only lift 5 pounds for at most 10 minutes because otherwise my wrists start to hurt and get swollen. Well, the doctor can check off less than 10 pounds, but that's not my story. That's not my complete story. My complete story is what I just told you. So the doctor could write here, Maria can only lift 5 pounds for no more than 10 minutes because if more than that, her wrist gets swollen, painful, right? That tells the story of my limitations. So you'll notice that in this document, it's all about the ability to work. These are all things that you would need, physical things that you would need to do to carry out work, right? What about frequently lift or carry? Standing and walking. Can Maria stand and or walk less than 2 hours in an 8-hour workday? And if the doctor has to explain it more thoroughly so it's accurate, then that's what the doctor should do. Sit, because there are jobs that require a lot of sitting, right? Pushing and pulling. And the doctor could put more information, to explain any of these here or next to it. It doesn't matter as long as the information is there. What about postural limitations? Can I climb? Ramps and stairs, ladders, ropes, scaffolds. Remember, they're trying to figure out if I can do any other work, right? Or if I can do the same work I did before. Balancing, stooping, kneeling, crouching, crawling. Manipulative limitations. Can I reach in all directions, handle things, finger things, feel? Visual limitations. What are my limitations with my vision? What about communicating? Do I have, if I have, problems with communication, they can't say that I can do jobs that require that I hear and speak, right? Maybe, if it's hearing, I'm going to need to have ASL or something. I'm going to need to have some kind of a reasonable accommodation. What about my ability to work in environmental things like cold and heat, humidity, noise, vibration, etc. More comments here. So this is that first form, and the doctor fills it out. The more information the doctor gives, the clearer the doctor is about the limitations, the better. Then there's the mental residual functional capacity form. This talks about Maria's understanding and memory. Does she have the ability to remember locations and work-like procedures? What about long-term and short-term very short or simple instructions, or longer and detailed instructions? What about under the category of concentration and persistence? Can I carry out a short and simple instruction, more detailed instruction? Can I maintain attention for extended periods of time? Do I have the ability to sustain an ordinary routine without special supervision? The ability to make simple work-related decisions? What about concentration and persistence? Social interaction. Do I have the ability to interact appropriately with the general public? If I don't at all, and they say, and I don't think this would happen, and they say, Maria, you could work in customer service. Well, how is that when I don't have the ability to interact with the general public? How is that going to work? So anyway, adapt to things. You see where this is going, right? This is all about work and your ability to work despite your disability. So like I said, these are forms that should be filled out and provided at a redetermination or initial application because it's information, and not so much for children, right? We're talking about adults, because for kids, it's if you don't meet the listing of impairments, you're not presumptively eligible. You're not in the list of compassionate allowances. You're looking at the 6 domains, and is there information with regard to that? So we have spent a lot of time just talking about disability. Now we're going to talk about the second criterion for SSI, which is income. It's countable income, because the program will always look at countable income, meaning they allow you to deduct certain things to get to countable income from gross income. We're going to talk about deeming, and I'm going to show you the amounts of SSI here in California. So when SSI is looking at income, it's looking at earned income, unearned income, pensions, interest income, dividends, etc. In-kind income. We're going to put a link to a publication from Justice and Aging about in-kind income. For all of you who are 18 or over and are living with people, you need to know about this, because if you're living with other people and you're sharing in the shelter and the food, you have to, let me step back. When you're on SSI and you live with other people, you have to meet your fair share of food and shelter. If you're not meeting your fair share of food and shelter, then SSI is going to say, wait a minute, you have people in the household who are helping you with food and shelter. And that's a form of income. It's a form of unearned income, and that has a dollar value. So the gentleman, I think, who said my daughter's getting it's not getting the full amount. I think daughter was 19, maybe. I don't remember. It's possible that they have found that she's not meeting her fair share of food and shelter. Social Security will send you like pages and pages of information where they want to know, what do you spend on food? What do you spend on shelter? Lots of information. And that's where they get the information to ding you with in-kind support and maintenance. That publication is really essential to read and to understand. So in-kind income, there are 2 formulas that they use, and that will reduce the amount of SSI that you get. Deemed income, remember, if you're a minor, your parent, and you're applying for SSI, your parents with whom you live, income and resources will count as if they were yours, and that could disqualify you because you have too much income, too many resources. If you are a spouse and you want to apply for SSI, your spouse's income and resources will count as if they were yours, despite the fact that maybe your spouse doesn't give you anything. Doesn't matter. And if you've been sponsored into the US, someone signed a document with the government saying that they would take care of you, and you become a lawful permanent resident, and you turn around and start applying for SSI after 5 years, and the sponsorship rules still apply to you, they can deem your sponsor's income and resources, and also your sponsor's spouse's income and resources. So that's deemed income. There are no exceptions. not like in Medi-Cal here in California, where there could be an exception if you're on a waiver. Not the case with SSI. So there are kids who are found disabled. They meet the definition of disability, but they can't get any SSI because their parents' income and or resources disqualify them from getting SSI. There are things that don't count as income. So this is really this is part of the work rule for SSI. So if you have any unearned income, you're allowed to deduct $20 to get to countable income. If you have earned income, they allow you to get your gross income, deduct $65. And if you didn't use your $20 unearned income deduction, you can use it here. And then you can divide by half to get to countable income. And if you have blind work expenses or impairment related work expenses, these are expenses that you pay out of your pocket to be able to work, and they're approved by Social Security, then you can deduct that from your gross income to get to countable income. It's all in the Red Book, and that's why you need to read this and talk to a WIPA. So other things here listed that don't count. These are just examples. It's not the whole world of things that don't count. And some of this stuff is more complicated than what is written here. Loans that you have to repay back. If you have any specific questions, it may require my research because there's sometimes it's not a yes or no answer. It's a depends answer, and it depends on the facts of your case. And so other things here. So this is for the work rules. For example, this is when you have unearned income, what you can do to get to countable income, because remember, they only care about countable income. So for example, let's say for a minor earned income, a minor parent, so they would apply the same work rules. They would get gross wages minus the 20 that they didn't use up, minus the 65, divide by 2. So the countable income that SSI is going to consider to see if you qualify for SSI is not the $317 gross income, it's the $116. And if you have blind work expenses, impairment related work expenses, it could be a lot less than this. So they would get, for example, if you're in a state where the state doesn't put in any money, this is the amount, for example, they would get the SSI amount that you would get and deduct the countable income, and that's the SSI that you would get, 678. So that's income, and there's more information here about deeming. And in California, so they have if you're in another state like Texas, Oklahoma, Arizona, there's something exactly like this for your state. So what I'm going to do is I'm going to explain California's amount. But the information, the amounts could differ from your state, but what I tell you about each one is the same. The amount that you get in SSI depends on a number of things. The living status that they put you under. Are you an adult in independent living status? That does not mean that you live alone. It means that you meet the criteria for independent living status. Maybe you are in you have a rent agreement. That'll put you here. Or you're living in the household of another. If you're living in a board and care situation, you're going to get a different amount. And your disability will also, if you're getting SSI based on blindness, you'll see that in some circumstances, you're going to get more than someone who has another disability not based on blindness, or people who are aged. If you're a minor living with a parent, the most you can get is $921.75. And if you're a minor living in the household of another, $645.79. Don't ask me why it's like this. It seems unfair, but anyway, but these are the California amounts, because this amount includes the federal portion and the California supplement. In your state, you may not have a state supplement, so the amounts will be less than this. And then there are amounts for couples who are both disabled, or maybe a blind spouse and a non-blind spouse. If you're living in a medical facility, your SSI goes towards that, and you're given a stipend by personal and incidentals. So anyway, so that this is, not everyone gets the same amount, and it depends on several factors, right? And the total amount depends on what state you live in, right? Because if your state isn't supplementing, then you're not going to get the amount that you get in California. I'm gonna go through resources, and then I'm gonna stop, and then I'm gonna answer more questions because there's still a lot of information to go through. And I just want to make sure I go through all of it. So resources, remember, you have to have countable income that is below the amount of SSI that you get. So let me give you a good example. Let's say that I'm independent living status, and I'm disabled, not blind. And after I do my calculations, my countable income is $1,100. Yet I would only get $1,040.21 under independent living status. I am not going to get any SSI because my countable income is above what I would get in SSI. You see? But if my countable income was $1,000, then what would happen is that they would take the 1,040.21, deduct my countable income of $1,000, and my SSI payment would be every month $40.21. That's how it works. So with resources, you have to have, you can't have more than, for a person, a single person, you can't have more than $2,000 in countable resources. A couple applying for SSI can't have more than $3,000 in countable resources. Countable, because there are things that don't count. Things that count are cash, stuff you have in bank accounts, stocks, savings bonds, land, except not the land that you live on, the home that you live in, and the land that is on the house. Life insurance policies of more than $1,500 face value. Personal property depends. The property, like your household items, don't count, but if you have personal property like a motorcycle and a car, the car is exempt, but the motorcycle will be counted as a resource. Vehicles, you could keep one, any value, it doesn't matter, but the second one will count as a resource unless you use that vehicle for work. Not to go to work, but for work. Deemed resources, we've talked about that. Things that don't count as resources, the home you live in and the land that it's on, one vehicle, we talked about that, personal effects. Burial funds, no more than $1,500 or less. Burial spaces for you and your immediate family don't count. And other things. Money in an ABLE account. You may live in a state that has the ABLE program. Here in California, it's called CalABLE. Maybe Mary or Lonnie, we could put the ABLE National Resource Center, since we have people from out of state. You can contact the ABLE National Resource Center to see if your state has an ABLE program. If you're on SSI and you open up an ABLE account, you can put up to $100,000 in that ABLE account without it affecting your SSI. It will not be counted as a resource. So you can, have money in your ABLE account and go on vacation, buy a home, buy a car, modify a home, pay your rent, your taxes. You can spend that money on what are called qualified disability expenses. Because if you don't have an ABLE account, you can't keep $100,000 and still be on SSI. The general rules would apply, right? $2,000 if you're in an individual, but having an ABLE account will allow you as an individual to have up to $100,000 without it affecting your Medi-Cal, your SSI. It's a great program. I do a training just on this. It's probably my favorite training because it's such a great program for people So, do explore the possibility of opening up an ABLE account in your state. You can open up an ABLE account in there are states that allow out-of-state residents to open up ABLE accounts. And the ABLE National Resource Center is a good thing. Things that don't count as resources, if you get a retroactive Social Security check or SSI check, you have up to 9 months to spend it down before it's counted as a resource. Scholarships, fellowships set aside for educational expenses, you can keep that up to 9 months before it's counted as a resource. And there are other things, health flexible spending arrangements, earned income tax credit payments are not counted for 9 months. We have a publication called SSI lump sum payments. Let's say you get a retro IHSS award, or you get an inheritance, or you win the lottery. Well, you have a certain time for certain things. You have a certain times to spend down before it counts as a resource. We're going to put that information, that link to that publication in chat so that you have it. If you want to sell a resource, be careful. Don't sell it for less than market value, because you're going to be dinged for up to 3 years. So be careful with that. Okay, so I'm going to stop right now before I talk about qualified alien status to see if there are any questions. Residents, after 5 years of being a lawful permanent resident, you can apply for SSI. Before that, you cannot. In California, we have a program called Cash Assistance Program for Immigrants. If you're in this kind of status, you might be eligible for that, and it gives the same amount of money as SSI, and the rules are very similar. If you have if I'm not an expert in immigration, I work with a couple of people at the National Immigration Law Center. When I have issues of, immigration statuses and benefits, I usually go to them, because this is not my area of expertise. But these are the seven categories of people who could apply. Obviously, a US citizen can apply, of course. Under what conditions? Okay. And so this is the whole 5-year deal. If you're a lawful permanent resident for 5 years, you have to wait until you're a lawful permanent resident for 5 years. There are people who can receive, these types of people can receive SSI for the first 7 years. The rules are a little different for people who qualify under these categories of immigration statuses. So I don't know where an H-4 visa falls into this. If it doesn't, if you're a California resident, you can always call me. I cannot do work for anyone outside of the state. But if you're, you can call me, and I may have to go to my expert in immigration to answer your question.
We live in Oklahoma, so I assume
Yeah.
I should be reaching out to one of your sister concerns.
Yes, to the Oklahoma Protection and Advocacy. They may have the information, or they may have to reach out to an expert. Like I use National Immigration Law Center. I don't know who they would use. Yeah.
Okay. And you mentioned about the family's income into consideration for the child's income. Is that on a whole
parents,
person, or is that?
It's not the family's income. It's the parent with whom the child lives, parent or parents. That's the only income that's deemed to the child, not a sibling's income that lives in the same household, or an aunt or uncle, none of that. It's only the parent's income, the parents with whom the child lives, income and resources.
Would that be considered as a whole, or is there a particular percentage amount that we need to be aware of?
Well, you have to add up the father's income, the mother's income, deduct do the deductions, $65. There are deductions that are allowed. And if the countable income, once you've done all of the calculations, is more than what the child would get in SSI, depending on your state. If the combination of your husband and yours countable income is more than what the child would get in that state in SSI, the child will not get any SSI.
Okay. Makes sense.
So that's
Thank
what happens. I mean, there are children who are disabled but cannot get SSI because the parents' income and resources are too much.
Okay, makes sense. Thank
Mhm.
you.
You're welcome.
Maria, there was a question on the SGA, the $1,350. Is that annually, monthly, and is it gross or
Monthly.
after
Monthly,
taxes?
gross, monthly and gross, and it changes every year.
Thank you, Maria. Can we go to, but I think I already did, Bajal.
I want to talk about SSDI because we have about 20 minutes. So I'm not going to read this. You're going to read this. You have rights as a beneficiary of SSI. You have obligations, mainly reporting changes in your household, income, resources. They tell you this, they give you information when you first get onto the program, because if things change, your eligibility for SSI may change, or the amount that you get in SSI may change. So you're going to want to look at this publication. Applying for SSI, you can do it several ways. You can do it online, you can call them. You can even now you can now go in and pick up an application and, and submit it. The offices are open as of tomorrow. So you'll have this document. Appeals, I'm going to just briefly go through all of this because this is all here. There are different levels of appeal. If you first denied, you're going to ask for reconsideration. Someone else at Social Security or DDS is going to look at the case to see if the initial decision was correct or not. If you're denied, you go to an administrative law judge hearing. If you're denied, you go to an appeals council review. And if you're denied, you go to federal court. Really, you don't really want to get anywhere near here. So you want to do the best job possible in the beginning. And this publication talks a little bit more about each level and what it looks like. So you'll have it. You might feel that you need representation. You might need an attorney to represent you either at the initial application or after a denial. You can, attorneys cannot charge you up front. They can only get usually 25% of any retroactive award. We were on a training once and a lady said, "Oh, I found an attorney who's charging me $5,000. And I said, "No, that's illegal." And the retainer has to be approved by Social Security. If the attorney wants more than 25%, the attorney has to petition Social Security to increase that amount. And they're going to want to know what's so special about this case, what was so hard about this case that you feel that you need more money. So there's information about attorneys. So remember, because attorneys will only get a fee if they win the case, they're going to only take good cases. So if you want to find an attorney, you're going to have to sell your case to the attorney. You're going to want to bring all of the documentation that you think the attorney will need in order to say, yes, I want to take your case. Because otherwise they're not going to take a case that they feel they're not going to win because they're not going to make any money. Now, fees are different than costs. Let's say, for example, I get an attorney and the attorney says to me, "Maria, we really need you to be seen by this expert and we need a report. And my health insurance will not cover that." Well, that's money I'm going to have to pay either up front or at the end of the case, whether I win or lose. Because it's something that the attorney needs. These are helpful suggestions throughout the disability determination, your application process. You can read it and it's pretty self-explanatory. I think what I'd like to do now is go to the SSDI. So I'm going to stop sharing. So Lonnie, you can bring up, and you're going to get this information too. The criteria for qualifying for Social Security disability insurance. The first one is that you have to be found disabled. We went through that for more than an hour, I think, about, you have to be found disabled. The second criterion, if you can scroll down to page 3 or 4, 5, actually, 6, that one. You have to meet the recent work test. So let's say that, can you scroll down so we can see the entire chart? Thank you. Let's say that I became that one, the first one. Thank you. So let's say that I'm 50 years old and I became disabled at 50. So not only do I have to meet the definition of disability, I have to meet the recent work test. And I have to show, because this says that if I became disabled at 31 or older, I have to show that I worked 5 years out of the last 10 years. Okay, if my last job was 10 years ago, I won't meet this recent work test and I won't qualify for SSDI. We have people calling us and saying they're denying this, and I worked, and it's because maybe they weren't found disabled. It's because maybe they didn't meet the recent work test. And then the other test that you have to also meet is, can you scroll down to the next one, please? The just the length of work test. So at 50 years old, I have to show that in my lifetime, I worked 7 years. This could be easier than the recent work test, I think. And the younger you become disabled, the easier it is to meet the recent work test. If you look at the other chart, you'll see that can you go back to the other chart, please? Yeah. So if you became disabled before the age of 24, you have to show that you worked 1.5 years in the last 3 years, right? So that's it. So that is how you get SSDI. And once you're on SSDI for 2 years, you get Medicare. Unless you have end-stage renal disease or Lou Gehrig's, you don't have to wait those 2 years, and you're going to get your Medicare right away. So what I'd like to do right now is go ahead and take any questions until 6 o'clock.
Maria, there's a question in the chat. What if a child is 18 and over, but is under conservatorship? Do the parents' income and resources still